So a very warm good afternoon from India, from Jagran Lakecity University, Bhopal. And it is my indeed a great pleasure, both on the personal as well as in the professional behalf, to welcome Professor Andrew James Harding, sir, Professor of Law at the National University of Singapore. So it is indeed a great pleasure, and we thank you, sir, for accepting our invite and addressing the August gathering today. And along with him, I'm also joined by the couple of faculty members from Jagran School of Public Policy and International Affairs. We have Mr. Raguraj Kullar, sir, the Assistant Professor, and Ms. Priya Sharma, ma'am, as the Assistant Professor, to join in for today's session. And without taking much of an time, I'll just quickly introduce the honorable speaker for today. So we have Professor Andrew Harding, sir. Professor Andrew Harding is a leading scholar in the fields of Asian legal studies and comparative constitutional law. He commenced his academic career at the National University of Singapore before moving to SOAS University of London, where he became the head of School of Law. He joined NUS from the University of Victoria, Canada, where he was the professor of Asia Pacific Legal Relations and director of the Center for Asia Pacific Initiatives. At NUS, he has been the director of Center of Asian Legal Studies, director of Asian Law Institute, and a chief editor of Asian Journal of Comparative Law. Professor Harding has worked extensively on constitutional law in Malaysia and Thailand, and has made extensive contributions to the scholarships in comparative law and development, having published over 20 books as author or editor. He is co-founding editor of Hart Publishing's book series, Constitutional Systems of the World, a major resource for contextual analysis of constitutional systems, and has authored the books on Malaysian and Thailand in that series. His most recent book is The Constitutionalism and the Legal Challenge in Myanmar in 2017. The subjects to which he is having an expertise includes law, governance and development in Asia, comparative legal traditions, public law, and his area of research includes Southeast Asian legal studies, comparative constitutional law, comparative law, law and development, environmental law, and Malaysian law. With so many things to speak about him, the list goes end on. But I'll have to stop in between, and now I'll request, sir, the stage is all yours to start with your presentation. I'll also request Raguraj, sir, who's managing his PowerPoint presentation, to run it across so that it can ease sir and the audience for today. Over to you, sir.
Dr. Devanshu, faculty, friends, everybody listening, thank you so much for the invitation and for the introduction. It's a great pleasure and a privilege to be in this kind of virtual room coming out of Jagran Lakecity University, which seems to be seems to be a wonderful university, and it's a great pleasure. And it seems quite a lot of people are logging on for this event. So welcome to all of you. What I want to talk about this afternoon is legal transplants and legal reform. And in addressing that, I want to address what I suppose is one of the most famous disagreements in legal theory, the disagreement between Alan Watson and Pierre Legrand on the subject of legal transplantation. This is probably an old chestnut for many people, because this debate has been rumbling on for a very long time. And some people might say, why are you revisiting something that is so ancient in origin? But it's my belief that this particular debate has never really been properly addressed or resolved. So a bit like you know, Alexander the Great trying to cut through the Gordian knot. I'm trying to cut through the Gordian knot of legal transplant in this lecture. So it might be a bit controversial for some of you, but I hope I can stimulate some ideas, and in the terms of your school, ignite minds. I think that's the expression you use on your website, which is really a great one. So can we change the slide, please? So here we have it. In the red corner, we have the Belgian legal theorist Pierre Legrand, the guy in the middle with the glasses, and then on the right-hand side in the blue corner, we have Professor Alan Watson, legal historian and comparative law professor from the University of Edinburgh. And incidentally, I'm very sad to tell you that Professor Watson passed away just a few weeks ago. And so in a way, I would like to make this lecture a bit of a tribute to his work and his knowledge as a great professor. Although I will criticize one or two things that he said, but I believe his contribution to have been extremely great. So let's move to the next slide. Now, first of all, really, what is legal transplantation and why is it important? Now, I guess in general terms, we regard a legal transplant as a situation where one system, which we call the Donee system, adopts a rule or an institution or a statute, or even perhaps an entire legal system from another country, which we can call the donor. In Watson's case, interestingly enough, if you look at his book on legal transplants, the donor system that he considers at great length is that of the Roman Empire. And he famously looked at the transplantation, or what we sometimes call the reception of the civil law system from the Roman Empire into medieval Europe. And you might think that that is really a very different kettle of fish from looking at whether, shall we say, India should adopt a rule that has been developed in Australia or something of that kind. But we'll come back to that point. So without, I think, many exceptions, legal systems across the world have all transplanted either the common law or the civil law as the basis of their private law system. And also, in many cases, they have transplanted the criminal law and public law as well as private law. I've mentioned here that, possibly Bhutan is an exception to the general rule. I can't really think of many other cases, but I think even in the case of Bhutan, they are heavily influenced by Indian law in various ways. So law reform in practice seems to be mainly delivered by looking at examples from other countries, from elsewhere. The thinking is very obviously, why should you reinvent a wheel that somebody has already invented? Why go to the trouble of that when people have gone to a great deal of trouble to figure out the issues? And problems that occur in one jurisdiction are very likely to occur in another jurisdiction. The question is, what should we do about it? So I would suggest that for every legal problem, there is actually a very limited range of solutions available, and nearly all of these solutions have been tried elsewhere. There may be exceptions to this. Some solutions obviously must have been developed originally in some jurisdiction. So what I say cannot be absolutely true, but I think nonetheless it is generally true. And interestingly enough, legal transplantation goes way back in history, right to the very roots of what we mean by law. There has never been a time when legal transplantation really was not happening. And I think that would include India, would include Europe, would include any part of the world. But obviously a big question about legal transplantation is, does it really work in practice? And Legrand has told us that legal transplantation is, in his terms, impossible. So is this really true? I'll come back to this point because I think there are serious issues even about what we mean by saying that a legal transplantation actually works in practice. Legrand even goes further to say that legal transplants are logically impossible, not just practically impossible. So all this forces us to think about how we ought to go about law reform. And I think also it compels us to consider the relationship between law and society. Next slide, please. I want to say a few words here about law and society, because I think as we work through, this will become a very important consideration in looking at legal transplants, where obviously you have a problem of the relationship between the transplanted law and the Donee society into which the law has been transplanted. So let's start with famously mirror theory. Legal sociologists, socio-legal scholars love the idea of law being a mirror of society. So when you look at law, are you really looking at society? Obviously, law is made by society. It's made by legislators, judges, and so on, who are part of the society that you are considering. So the thesis here is law is a mirror of society. Society makes the law according to its own values. But equally, some people might say, well, hang on a minute, society is also, isn't it, a mirror of law? After all, the law also constructs society according to its various categories. For example, family relationships, being a wife, being a husband, a son, a grandfather, or whatever, your job status as an employee or an employer, could be your status as a tenant or a landlord or an independent contractor, a parent, a trustee. Well, the list can go on and on and on. But the point is that people argue that society is also constructed by law, not just law constructed by society. So it's a fascinating question. What is the relationship between these two things, law and society, which we can, I think, endlessly consider. But obviously, to be effective, law must be largely understood and in practice observed voluntarily by society. If society is unwilling to observe a law as a whole, then as opposed to individuals within society, then it becomes very difficult to think of law as an effective force. So lawmakers need to know what will actually work in practice. And that is an issue where you have to look at society, not just to look at the authority or the excellent drafting of the law itself. But this obviously makes legal transplants very difficult. I would argue that it doesn't make transplantation impossible, but it certainly is an obstacle that we need to consider. I think we all recognize that there will always be a gap of some kind between law and society. And I guess in India, that's not a point that really needs to be made, because I guess it's pretty obvious. You find some countries where that gap is relatively small. Where I am in Singapore, for example, the gap between law and society is surprisingly small compared with most countries, because most people internalize and respect and observe the law, and they will soon find problems if they don't observe it. But maybe that's easy in a small island city-state like Singapore, not so easy in a vast subcontinent like India. But okay, what is the significance of what I'm saying then for legal transplants? And here we come on to it. Let's change the slide, please. Now, what I want to argue here is that Watson and Legrand have set up a number of binaries in setting out their theoretical positions. And I want to challenge basically all of these binaries that they have set up. You know, I'll give you a hint. It's a way of becoming very famous if you set out the most extreme position that you can reasonably express. that you believe in, because then everybody else has to define their position in relation to yours. And therefore you get cited many times and you become very famous, like Watson and Legrand, both of them at either end of this spectrum on legal transplantation. So let's have a look at what they actually say. Now, Watson says that legal transplantation is possible. Law develops mainly, he argues, via legal transplantation. This is a very big claim. Whole systems or individual rules can be transplanted. And moreover, he says that this does not depend on the conditions of the, I'm sorry, I made a mistake here, the donor system. Right? It may depend on the conditions of the donee system, but not on the donor system. So that's something we'll come back to. Obviously, in his case of the transplantation of Roman law from the Roman Empire to medieval Europe, it would be very difficult for us to check the legal conditions of the Roman Empire. And essentially, we do not know how law operated in the Roman Empire. There are people currently researching, trying to find that out. But frankly, we don't know the answer to that. But Watson would say, well, it doesn't really matter, because what matters is, will it actually work in the donee society? Never mind the donor society. And he goes further to say that this aspect of legal tradition, which is involved in transplantation, is protected by the legal profession. So he believes very much in the sort of the adhesiveness of law and the fact that the legal profession plays a really important role in securing that adhesiveness of law. And you might want to think about the common law system in India, because obviously that was introduced by the imperial power. The dastardly British introduced this law, but you still got it. So what explains the fact that you still got the common law system? And it's amazing, you know, no country ever voluntarily adopted the common law system. No country has ever changed from the common law to the civil law, and no country has ever changed from the civil law to the common law. So think about that in terms of legal transplantation. Well, let's come on to Legrand. Legrand argues, on the contrary, that legal transplantation is impossible. He says that differences in societal conditions are determinative of the issue of legal transplantation. He argues that Watson is guilty of describing rules as mere strings of words, which are insignificant on their own. Legrand argues, so this is an interesting argument, that rules are only given meaning by the cultural or societal understanding of the rule. Therefore, so-called transplanted rules become something different from the original rule. Therefore, there is, strictly speaking, no transplantation. So in this idea, he claims that rules have, along with the mere string of words, a kind of baggage of cultural interpretation. And this is an important and kind of interesting point that we might think about. And it prompts us to think about, well, what actually are rules when it comes down to it? This is a fundamental question, I think. Now, when he says that legal transplantation is impossible, what exactly does he mean? Does he mean that it's practically impossible or logically impossible? The argument that I just set out seems to indicate that he regards the transplantation of rules as somehow logically impossible, because part of what we mean by a rule is that it has this kind of cultural baggage, and by definition cultural baggage cannot be transplanted from one society to another. Therefore, there is no such thing as transplantation. But at other points he seems to take a slightly less strong view and say that legal transplantation is something that is practically very difficult to achieve, rather than it being a logical problem. So another debate that all this raises that I'm find very interesting, but I'm not going to go into it too much because there's not time in this lecture, but I'll leave it to you to think about, is whether legal transplantation is possible only in private law, or is it possible in public law as well? Some scholars, I don't include Watson and Legrand here, argue that legal transplantation is possible in private law, but is not possible in public law, a position which I profoundly actually disagree with, but that's what some people say. Next slide, please. So these are the theoretical positions, the two binaries. Now, when you look at this debate, it obviously gives rise to a number of questions that are sort of anterior to the debate itself. And for example, what exactly do we mean by law when we say transplanting law or legal transplantation? What do we actually mean by those terms? Of course, what do we mean by transplantation? When do we know that a transplant has taken place? And then, as I've indicated, what exactly is a legal rule? Is this a product of language, or is it a product of a legal process to produce a rule, or is it a product of society? Mirror theorists will say that legal rules are always the product of society, but is that really true? That's something, again, for us to think about. More practically, how should we go about law reforms? I mean, what do these theories tell us about the process of law reform? And that's the matter that I want to emphasize towards the end of the lecture, because this is really the practical implication of this debate. It's not pure legal theory, it relates to how we actually go about law reform. And can we in practice reduce the gap between law and society, particularly where we find that law has been transplanted from another jurisdiction? Change slide, please. So those are just some of the questions. Now I want to here in the next two slides interrogate, first of all, Watson and then Legrand. All right, let's have a go at Watson first. Is law really detachable from the society where it was developed? Watson sets great store by the sort of abstract nature of law. He says that laws can be abstracted from the society that produced them. And this makes transplantation possible because any society in principle can adopt that abstraction, right? Now, of course, if he's right, that makes it relatively easier to transplant law. If he's wrong, it makes it very, very difficult to transplant law. This is the fundamental point. So, do we really not need to know how law functions in the donor system? Right? I want to question that. Watson says no, because if you abstract law from society, then you don't really care what society has to say about it, or how society produced it, or whether it actually works or not, because it's only the abstraction that counts. And obviously here you could look at the Roman Empire and say, well, we don't really know or frankly care how law actually worked in the Roman Empire. The point is they had a great code, the Corpus Juris Civilis, which has been spread to 3/4 of the countries across the world. A magnificent, if you like, abstraction from Roman society. We don't care about Roman society. But is it really true? I mean, if you were a law reformer looking at a law in another jurisdiction, would you not want to know whether that law actually works effectively in that jurisdiction? Supposing you transplanted it, and then lawyers from that jurisdiction say, hang on a minute, you've made a big mistake here because, you know, that law doesn't work in our society. Why should it work in your society? Yeah. One of my students the other day came up with a great example of this. Apparently, Nigeria just transplanted Singapore's law on infectious diseases. And you can imagine why they did that, because we're now in a situation where the law on infectious diseases is very, very important. And they transplanted the Singapore law absolutely word for word from Singapore to Nigeria. You can't imagine two more different societies, right? In fact, the legal transplantation has proved to be quite ineffective, because they didn't really understand why that law works in Singapore and why it would not work effectively in Nigeria. Unhappily, the examples of this are so many across the world. We could spend the rest of the day talking about horror stories of legal transplantation. I'm sure you know, from your body language, you've got a few examples of your own that fall into that category. So don't really historical, social, economic, political factors really matter with regard to the ability of law to survive transplantation? Is Watson really right about this sort of abstraction of law from society? But okay, we've challenged that. But I think, as with Legrand, there are also things to learn from Watson. And I think Watson has taught us that legal transplantation, or whatever it is you call legal transfers cross-jurisdictionally, there may be issues about terminology here, but let's leave that on one side. Whatever you call it, is it not the major method of legal change across the world and across time? Right? Now, I believe in this respect, Watson's theory is observably correct in practice. And here I'm looking at what in my article I called the real world of legal diffusion. And, you know, as somebody who studies law and development, I'm very interested in this process. And I don't think that either Watson or Legrand has really bothered to sort of go out into the real world to find out whether their theories actually correspond to reality. And this is a criticism I level at both of these scholars with their very different points of view. You cannot, I argue, understand the process of law reform and legal change by sitting in an office in, you know, Louvain or Edinburgh or wherever it is, you know, trying to figure out how this works. You have to go out into the empirical real world and see how it works in practice. So next slide, please. Now, let's apply the same sort of critique to Legrand. Now, Legrand says rules are not strings of words. He says Watson always just thinks rules are strings of words. I want to challenge that. Aren't rules, in fact, strings of words? Right? I mean, think about what we mean by a rule and what it would mean to transplant a rule from one society to another. In other words, what I want to say here is that rules are actually strings of words that have a legal meaning, right? Not just, as Legrand argues, a social meaning or a social application. So I want to challenge here the idea of the rule with its cultural baggage. I'm saying rules actually do have legal meaning. They are not merely strings of words. And, you know, we can talk about examples. I'll come down to some examples a bit later on. But I want to just briefly note in passing here that, of course, not all law consists of rules. There are also, for example, principles. There are also, basic positions about how you interpret laws. There are rationes decidendi of cases. Aren't those also law, not just rules that you read off a statute book? So I think both scholars are a little bit narrow in their definition of what law actually consists of. And if Legrand's argument depends on all laws being strings of rules, then I think that is very easily disproved. All laws are not strings of rules, right? Okay, moving on. How does Legrand, I want to challenge, account then for legal transplantation as a global fact, which I allege that it is? What then are we doing globally if we are not transplanting laws in the process of law reform? Legrand doesn't give us any theory or any concept to explain this. He just denies that it happens, right? It's either practically impossible, you guys are wasting your time, or it's logically impossible, I don't know what you're talking about, right? But in both cases, that seems to be quite wrong. If you look at the process of law reform, more of this is happening than has been happening at any previous period in human history. So I don't see how you can say, you know, that this is something that simply doesn't exist. It's kind of a myth. It's not a myth. It's a very expensive everyday reality that happens. Okay. So now, I think as we've seen, almost all law, and I look at Southeast Asia, so I'm going to use examples from Southeast Asia. Almost all the law in Southeast Asia was transplanted from somewhere else, except possibly for customary law. I would guess that those of you who know much more about Indian law than I do would probably say the same about India. Yeah, you know, maybe you'd argue that Hindu law is a kind of an indigenous product of India. Okay, fair enough to say that. Law based on religion or custom is very often developed within the jurisdiction, and I'm very happy to cite that as an exception. So it seems as though perhaps Legrand is objecting to our use of words rather than our use of law, because if you look at this from the perspective of a region where most of the law has been transplanted from elsewhere, then you'd be forced to argue that it basically doesn't have any law because there's no such thing as legal transplantation. So Legrand is very puzzling, you know, in terms of how you explain the development of legal systems. He doesn't really give us a theory to deal with that. So that's one of my objections. I mean, finally, you know, what is in this interpretive baggage? Do rules really always have such baggage? Is this really true? Let me give an example. Supposing you have a rule that says that a person can only enter into a valid marriage if they have attained the age of 18 years. I don't know, is that the rule in India? I'm not sure, but in most countries, you know, it's 18 years or it's 21. But anyway, you've got a rule that specifies how old you have to be to enter into a valid marriage. Now, what is the cultural baggage attached to that rule? Because that rule has been adopted in many, many countries across the world. Could you even conceive what the baggage might be? Well, okay, maybe in some cultures people are regarded as adult earlier than in other cultures. Fair enough, but what on earth does that have to do with the rule? Nothing at all, right? So I think there are rules, and I would argue there are lots of rules that really don't have this interpretive baggage. I mean, if you're told it's illegal to park your car on a double yellow line, what's to not understand about that? What's cultural about not parking on a double yellow line? Well, okay, somebody might say in India, but people park on a double yellow line all the time. Yeah, they ignore the rule. That's not an interpretation of the rule, to be correct. That's simply refusing to abide by the rule, which is a different matter. Right? So I want to challenge this idea of rules having cultural baggage attached to them. Culture may explain why the rule was created in the first place. Culture may explain why it works or it doesn't work in a given society, but that's not the legal meaning of the rule itself. So in that sense, perhaps we can go with the idea of rules being abstracted. Law can be abstracted from society. But I want to make another point here, which is often overlooked. Law reform seeks to change society, not to reflect it. If you regard law as a mirror of society, then it follows that you can never reform law itself. You'd have to reform society first, and then society would reform the law, because the presupposition is that law is always a mirror of society. Therefore, according to mirror theory, which Legrand would subscribe to, law reform is an impossible task. because you'd have to change society first. But he doesn't give us a theory as to how to change society, unfortunately. Yeah. But I, again, want to refute this as an observable fact, because we can see examples where law is actually effective in changing society. Societal changes have, in fact, been accomplished by law. And so if Legrand were to go along to a law reformer and say, look, you know, this is a waste of time because law cannot change society. You cannot transplant law from elsewhere and expect that to change society. Well, I think the law reformer is going to be pretty impatient. He's not going to pay Legrand as a consultant for this, because he's going to say, well, look, the whole point of this is that we want to change. We don't want the law to reflect society. We want the law to change society. And I think Legrand really misses this. But on the other hand, maybe his thesis teaches us to believe that we should exercise care when transplanting law. And that part of it, I would wholeheartedly agree with. And I think that Watson, in a way, would also agree with that proposition. Actually, sometimes Watson says it's easy to transplant law, and sometimes he says it's difficult to transplant law. So it's not quite clear what his position is on the ease of transplantation. And some people have talked about strong Watson and weak Watson. Okay, next slide. Well, let's talk a little bit about types of law and whether they can be transplanted or not. Now, the civil law system interestingly distinguishes private and public law, whereas the common law doesn't. And it's interesting that civilian scholars are the ones that say that public law cannot be transplanted because they say political systems are very different from each other, whereas that is not a consideration when it comes to private law. I'm not really sure about that, but that's what they say. So public law, they say, relates to political structures which differ across societies. But it's often difficult, you know, to categorize law as public or private. This is a very sort of civilian lawyer's idea, I think. It's not a common lawyer's presupposition. For example, is environmental law public or private law? In some ways, it could be public. In other ways, it could be private. It depends what the issue is. And in fact, again, observably, public law has in fact been transplanted. The Westminster parliamentary system, for example, has been transplanted, so has the American presidential system. Constitutional monarchy even has been transplanted. Separation of powers, human rights law, administrative tribunals, ombudsman, all sorts of facets of public law have in fact been transplanted across jurisdictional boundaries. And I think these ideas are even not wholly irrelevant in socialist one-party states or states under military government. For example, looking at Thailand, which was under military rule between 2014 and 2019, the number of cases in the administrative courts increased during that time. So are political differences always really decisive, even in the area of public law? But okay, I think I would accept that private law is easier to transplant compared with public law, but it's not impossible to transplant public law. Next slide, please. Now, you may not like the poetry of Kipling because he was a British imperialist, right? But he's got this wonderful phrase, triumph and disaster, treat those two impostors just the same. This is a wonderful advice, I think, especially when it comes to legal transplantation, because we may very easily mistake success for failure or failure for success. So what does it mean to obtain a successful transplant? How can we define success? Even when can we assess success? I mean, how long do you have to wait in order to discover whether your transplanted law is successful? or not. Now, I suppose the rejection of a law might be a test of lack of success, and equally maybe longevity is also a test of success. I mean, if you look at the transplantation of the civil law system into Japan, for example, the transplantation of the French Civil Code was not successful. They rejected it. They then adopted the German BGB, which was the fresh off the press, modern version of civil law in the 1880s, and that still applies today with very little amendment. So one unsuccessful, one successful. So maybe, time and rejection would be very important here. As I said, in Southeast Asia, there have been many legal transplants resulting in an extreme form of legal pluralism. Legal transplants have generally survived, and some have not. But does the survival of a transplanted law necessarily mean that it's successful? For example, Thailand transplanted constitutionalism and constitutional monarchy in 1932. It's a long time ago. It's 88 years ago. They're still struggling with that transplantation even now. There was military government right up to 2019, and now you can see on the streets in Bangkok, students are protesting about the 2017 constitution. They've had 20 constitutions in their attempt to find the right balance and to successfully transplant constitutionalism. So it would be very hard to say this is a successful transplantation. Alex Stone-Sweet, my colleague at NUS, produces the following bit of theory. If a law is used and its use is generally recognized as determinative, then we can call it successful. Does this actually work as a test? Is this always true? I'm not quite sure about that, because there may be cases of a successful transplant where the law is not being used, and maybe it is a sufficient disincentive and therefore successful that nobody actually wants to test it. But that this might be an area you might have a few questions about this as a test of successful transplantation. As a lawmaker, I think you would want to know when a law has been successfully transplanted. And many countries now have a law on legislation which requires them to investigate what other countries do in response to the same problem. And they also require the government to investigate both before and after the fact to find out what the impact of the law actually is. So regulatory impact has become a big issue, rightly so. We need to know these things. Okay, change slide. Now, let's come back to the question whether some kinds of law are more easily transplanted than others. I mentioned private and public law. What about personal law and what we might call technical law? Commercial and corporate law seems to be much more readily transplanted than other kinds of law. Is, for example, company law in India, is it very different from Canada or Singapore? Probably not that different, I would guess. I'm not an expert on Indian corporate governance. I'm sure there are people here who are expert, but my guess would be that it's not really that much different in practice. But family law is going to be what assumes pretty different across jurisdictions, because family law is more closer to social and religious values than, say, corporate governance would be, and therefore more difficult to transplant. However, rules about divorce have been transplanted in a very similar way across many jurisdictions. So maybe this is not an absolute rule. And then what about regulatory law? That would be something to think about. Well, here are some examples. Consider, regressive taxation, the idea that the rich should be taxed more than the poor. Is it really difficult to transplant that? I would argue that's a legal idea, not a law as such. What about insanity as a defense in criminal law? Nearly every country recognizes insanity in some form as a defense in criminal law. What about divorce without fault? Over the last 100 years, many, many countries have adopted such a law, even though it relates very closely to societal values. But guess what? Society values have changed, you know, and now ancient divorce law is oppressive to women. Yeah. And so you need to reform the law on divorce, and most countries have done. What about the idea to take an institution of a police complaints commission? Some countries have it, others don't. It can, in principle, be transplanted, I would argue, from any country to any other country. But do we really need a transplant to do this? Isn't having a police complaints commission just an idea? Do you have to adopt any particular model of it? Not really. You can have your own version of a police complaints commission. I have no problem with that. Well, okay, we can go on elaborating examples. I think I've made the point here that there are simply some ideas that are useful to transplant, and you don't necessarily need to look closely at, you know, what does the law of Australia or what does the law of Bangladesh say on this particular issue. But in general, I would argue that the closer law is to social values, the harder it is to transplant. In other words, the more technical it is and the more it relates to commercial transactions, the easier it will be to transplant. But this is not the same as saying that something is flawlessly possible or completely impossible. It's possible in all areas, but it's not necessarily easy in all areas either, right? And I think most people who do law reform or who practice in law and development would say that this is it's just too obvious to be worth stating. We all know that legal transplantation is possible. We also all know that it's difficult. Next slide, please. I don't want to take up too much more time, but I thought it might be useful just to elaborate some examples from my own experience from East Asia and to make one or two points about the way this process of transplantation works. Let me take, for example, a very obvious one. Both China and Thailand have adopted the trust from the common law system, right? Or equity, as we call it in the common law. How has that worked out? Well, in both cases, you know, they have a civil law system. So transplanting the trust from the common law has been quite problematical because it conceptually doesn't fit in the civil law system. And obviously, they couldn't do this by judicial decision because judicial decisions are not binding in the civil law system. So what they've done in both cases is to introduce a statute where they use the idea of a trust, the idea that a person can vest property in another person for the benefit of a third person, and that second person is the trustee who has certain obligations to the settlor and the beneficiary. I mean, you know the law of trust, that's how it works. So they pass a statute, they use this as an idea, but if you were to ask, well, have they transplanted the whole of the English law of trust? Well, no, of course not. That would be really foolish, right? And of course they haven't done that. Similarly, China has adopted from the common law the idea of publishing leading cases. The idea of law reporting was found to be very good in China. And so they have a system of publishing guiding cases, but it works very differently from the idea of law reporting that you would be familiar with in a common law system, right? The leading cases are not binding law, they are for guidance of courts across a vast jurisdiction. And so it works in a very different way from the system of law reporting in the common law. Well, I can give you lots of examples, but my conceptual point here is that in practice, what we are more likely to do is to transplant the idea of a law rather than the law itself. Now, obviously, there are examples of sheer ordinary transplantation of a law. I mean, I've mentioned one, the transplantation of Singapore's law on infectious diseases to Nigeria, which is not a very good story. But the point is that it was a transplantation word for word from the Singapore law. But I would argue that this is actually these days quite unusual. What is more likely to happen is the adoption of an idea. And very often you don't even need to specify where that idea came from. Yeah? The idea of registering marriages, is that really a legal transplant, or is it just an idea that many countries have found attractive? I think it's an idea, right? And I've mentioned in the slide, you know, the way in which the Constitutional Court in Taiwan struck down the provision in the Civil Code that prevented same-sex marriages and required the Civil Code to be amended accordingly. Did Taiwan look at a model of same-sex marriage in enacting this law? No, I don't think so. They were simply obliged to come up with something as a result of the Constitutional Court decision. So it was just an idea, but it's not a specific law. Okay, let's move on to the next slide. So what are my conclusions here? In my examples, what is being transplanted is not necessarily a law in the sense we've discussed. More usually, it's a legal idea which then needs to be adapted to the receiving system. So the whole point is the system of adaptation. How do you do that? Legal transplantation, I argue, is not a fiction, but perhaps we need to be more careful about the terminology we use to describe it, and I've suggested terminology in my written paper. And secondly, the process of absorbing a new legal idea into a receiving system is something that we need to know a lot more about. So this process leads, I think, naturally to a consideration of law and development and the efficacy of the process of law reform, which I think would be maybe a subject for a different lecture, but I'm just leaving it there. And if we can just change the slide, then I can just say thank you very much for listening, and I hope that was useful and interesting for you. Thank you.
Yeah, thank you so much, sir. That was indeed one of those specific of the lectures where the concentration on the entire topic of legal transplant and law reforms were there. And there were questions popping up during the lecture. So I'll take one question at a time, and looking at the paucity of the time, I'll take maximum of 3 or 4 questions as may be allowed. So the first and the foremost question which is there, this question is by a first-year student, that what are the benefits of having a minimal gap between the law and society? What India and similar countries should do in order to reduce this gap between the law and society? So this question has been posted. Yes.
Right. Shall I answer that now, or do you want to gather a few more before we proceed? Up to you.
No, sir. We'll take one question at a time. So I was just saying that this question was posted by Prerna, and yeah. So your answer in that.
That's a great question, or rather 2 questions I think involved there. What are the benefits of reducing the gap? I guess in a very simple answer would be legal certainty. And if you think that this is basically a question about the rule of law, isn't it? If you believe that the rule of law is a good thing, then you will believe that legal certainty is a good thing. If you, on the other hand, reject the whole idea of binding law, and you think that values and norms should be simply invented by society, and I don't think many people do think that these days, to be honest, then you would be quite happy with the gap between law and society, but personally I wouldn't be. I'm not sure that I'd be very happy with a complete identity between law and society. In a way, a gap may be quite a healthy thing, so long as the gap doesn't become too wide. Society maybe needs some space in order to sort of wrap itself around the law. Yeah. And if you have too close an identity, then maybe your system is becoming highly authoritarian, and you might want to think about whether that close identity is really such a good thing. But it's a great question. And what can we do to reduce the gap? That is a very, very big question. And I think that is something that socio-legal scholars across the world are investigating and looking at all the time. I would only say that the way to go about this is that we need to take law and society studies much more seriously than we do. I simply don't understand the assertion that I've heard made on many occasions that sociological study has no place in a law school. Right? I think it has a very important place in a law school, because otherwise your legal study is going to be incredibly abstract, and you're going to be studying legal theory rather than what happens in practice. Why, as a lawyer, as a judge, as a policeman, never mind a legal scholar, would you not be interested in how to reduce the gap between law and society? You know, if you want, as a policeman, you want people to comply with the law, makes your job much easier, then, you know, you'd want to find ways of doing that. So I think there are many different answers to this question. I think a judge or a policeman or a lawyer or a professor might produce very different answers to that question, but it's a very important one. Thanks for raising it.
Thank you so much, sir, for that answer. And I guess that one thing that I can pick from your answer was this itself. Yes, different eyes or different wing of the society would have a different answer to this particular question. And surely agreeing to the point that, yes, if you're not teaching social legal analysis, we are just teaching law in abstract. So perfectly answered. That moves me to the next question. Whose view, or do you advocate for a midway of the views on legal transplantation in practice? So the question is in position to you, that with your experience, which view would you be opting for? Whether it would have been the view for the Legrand, or the other way around, or the midway that you have been advocating?
Well, I would advocate they should adopt my view, because I think my view is the correct one. But okay, let me put this a little more modestly. I think these two scholars have set out two extreme positions, right, which I think are both impractical. Right? I think both have insights and both have made mistakes. Yeah. So I find myself somewhat in the middle, but tending a little bit more towards the Watson end of the spectrum, because I have real difficulties conceptually with Legrand's position, which I think ultimately doesn't really go anywhere. It just says, well, we can't do this. It shouldn't be done. If you deny legal transplantation, then you are saying that virtually the whole of legal history should be cancelled, because it's not possible to do it. I think it is possible, but I think we can learn, that it is not easy in practice to do it. And I think we should study a lot more how to go about this. I do not, for example, find that in this discipline that we call law and development, that we have learned very much over the last half century or so. I think we're still making the mistakes that we used to make in the past. In fact, in some ways, we did it better in the past than we do it now. So I think there's much too much kind of, rapid transplantation. People often have the idea that once a law has been adopted, then you've achieved the objective. And this is quite wrong. I mean, politicians love to stand up and say, look, I've achieved this legislative reform. And I'd want to ask, well, yeah, but okay, fair enough. But you have got to the starting line saying, I have won, I have won. That's only the starting line. I want to see you run the race first before you say you've won.
So thank you so much for that answer. The third question is, why do you feel that Southeast Asia has become a hub for legal transplants in practicality? So when we compare it with the world thing across, Southeast Asia has been that area where the maximum of the legal transplant beats. So it's China, Thailand, Bangladesh, as you cited across, India per se as well. So the maximum of the transplants, the legal transplants took place was in the Southeast Asia. Any particular specific reasons?
I think that's a great question, and it's actually quite a puzzle, because there isn't really any major sort of civilizational development in Southeast Asia, such as Hinduism or Islam or the common law or whatever that was actually created within the region, so that I mean, Hinduism was transplanted from India. I mean, Southeast Asia used to be a Hindu area in the past, and then Islam came in the 15th century. So parts of it are very Islamic and others are not. Buddhism obviously had huge influence as well. So it's a kind of, it's partly, I think it's the geographical position of Southeast Asia, poised sort of between the areas of South Asia and the Middle East on the one hand, and East Asia, China on the other hand. And then, the fact that they had so many colonial powers. I mean, the British, the French, the Dutch, the Spanish, the Portuguese all had their impact, and the Americans as well, all had their impact on the present legal systems in Southeast Asia. In East Timor, they look towards Portugal. I mean, a lot of their law is actually Portuguese, even now. In Indonesia, they look towards Leiden, the Dutch sort of, the mother of Dutch universities, for inspiration. I mean, I think that maybe this is quite wrong, but that's what they actually do. So it's an amazing, and not only those systems, but even customary law has been transplanted. Chinese customary law was transplanted from China right across Southeast Asia. When I'm in Singapore and Malaysia, I see Chinese customs all the time being implemented. And you know what is interesting here? That there's transplantation even between the systems of customary law. I mean, I found, nobody's written this up, but I found out that it's famous in Southeast Asia that in terms of customs on divorce, the woman gets what she brought to the marriage, the man gets what he brought, and what they created together, they divide equally between them. And I thought, this is a rule in the customary adat system in Malaya, and I find that actually it applies across much of the region. And so it must have been transplanted at some point in the past, but we don't know how or when. Right? So transplantation happens everywhere, and it results in legal pluralism. I don't think there's anything particularly special about Southeast Asia, except the extent of legal pluralism, because you can also look at India and other places in terms of legal pluralism.
Yeah, thank you, Professor, for that answer. I would also put a counter question on that don't you feel that it is more towards the adaptability, or the countries that were adapting those particular things were more liberal towards a point, or they were more ready to adapt those particular laws? Can that be also a reason of getting a wider number of legal reforms out there, or the legal transplants out there?
Yes, I mean, I totally subscribe to that. I mean, I'm in print saying that that's the defining feature in Southeast Asia, is the ability to sort of embrace and consume, internalize legal pluralism. Again, it's not unique to Southeast Asia, but it is an important feature, and I think I could give you many examples of that. Right across the region, even in relatively monolithic societies like Thailand, for example, and Vietnam.
Yeah, so thank you so much, sir. And I guess this would be the last question for our session. And this is more towards the school-specific question. That what according to you was the role of public policy when it comes to the framing of the legal transplants or the legal reforms? In both the cases, the role of public policy for that.
The role of public policy is absolutely preeminent, because when you are transplanting law, it is a deliberate legislative act, usually. I mean, not always, because let's recognize that sometimes judges transplant law through making judicial decisions. But for the most part, it is a deliberate legislative act in pursuance of a particular policy. The question really is what law will fulfill that public policy best. Yeah? And I think it is perfectly normal and perfectly fine to look at how other countries have approached the same policy issue, because what impresses me, and here I would contradict Legrand, is that very often, we're faced with exactly the same problem that is faced in other countries. Look at COVID-19. We're all experiencing, as you said earlier, we're all experiencing the same problem. The question is, how do we deal with it? And, the idea of social distancing is not peculiar to one society that happened to find this solution. It's something we can all do, right? So I think, public policy is extremely important. And I think that Legrand's analysis basically completely misses this point.
Yeah. So thank you so much, sir, for this answer. And that would be that was the last question for the session. And that would also bring us to the end of this particular and most elaborative session on legal transplants and law reforms. So on the behalf of my entire university, Jagran Lakecity University here in Bhopal in India, and on behalf of my school, Jagran School for Public Policy and International Affairs, I want to extend a thanks and a gratitude to Professor Andrew James Harding, sir, for sparing out his time, for sharing this wonderful knowledge, and yet igniting the minds, the concept of which this lecture series is based upon. So I'm pretty sure that the questions that the audience had in their mind, the sort of answers, and also giving some thoughts to think and prosper upon. So thank you so much, sir, for being there, for being with us. And yes, surely, as we discussed it, this is the first step towards the relationship that we have been entering into. And looking forward for your help, support, and commitments. And we are assuring you that any help or any joint projects that you wish to have or which is there, I would also like to congratulate you for the paper that you just shared with us, on the legal transplant and the law reforms. On reading like couple of readings on that particular paper itself has made the entire concept clear, and it's also focusing me to write something on that. So definitely it would be a great thing to write and to be in contact with you. So thank you so much, sir. And on behalf of my entire university, entire school, and on my personal behalf as well, I'd like to thank you for being here and sparing out time and thinking with us.
Well, thank you so much for the invitation. It's been an enormous pleasure, Dr. Devanshu, and I look forward to seeing you all again. And I would be delighted to receive any comments that you have on my lecture or on the paper. So everybody there, take care, and I look forward to seeing you again. Thank you so much.
So much, sir. You also take care, and we'll definitely share the pictures and the videos of the session with you as soon as we get it across. So thank you so much, sir. Right. And I'd like to thank the audience as well for being a patient listener and for their questions. I hope the answers given by you would be taken care of. If in case your answers or your questions are not being taken ahead, you can email it to me. I'll surely get this thing that it reaches Andrew, sir, and it gets answered as well. So thank you so much. I'd also like to thank Kuve sir for the all background support which he has rendered, and the team for Parul ma'am and the team members for the creatives and for other things. So thank you so much. And on that note, I bid a farewell to sir and to all my audience. Thank you so much.
Okay, thank you. Have a good evening and stay safe.
You too, sir. You too, sir.
Okay, bye-bye.